Crypto Twitter is awash with the rumor of SEC Chairman Gary Gensler resigning from the regulatory agency. Pro-XRP attorney John Deaton commented on the rumors, saying a Gensler resignation. U.S. Securities and Exchange Commission, SEC, has replied to Judge Torres' groundbreaking order from the July 13 U.S. session. This followed the long-awaited summary ruling in the Ripple FZ SEC lawsuit. Annalisa Torres, the presiding judge, found that XRP is not a security in certain situations. The SEC replies to Ripple's shared victory. The U.S. SEC returned home with a partial victory and will battle again another day. Following the court's judgment, the Commission has declared their position in response to outrage and derision from XRP community members. According to Fox Business, the SEC may decide to pursue the issue further. To paraphrase a section of the answer, nonetheless, the agency celebrates its own triumph when the judge determined that Ripple offered and sold the tokens as investment contracts in violation of the securities laws in certain circumstances. According to the court's ruling, Ripple broke securities regulations by selling XRP to institutional investors. Judge Torres granted them permission to sell the asset to the general public. A summary judgment review reveals that the court agreed with the Commission that the Howey test regulates the securities examination of Bitcoin transactions. Ripple's view of what constituted an investment contract was similarly rejected by the court. Nonetheless, the court's judgment has made it obvious that the SEC does not have limitless authority over cryptocurrency, which may help to explain the crypto market's excitement. The Kraken and Coinbase exchanges have already responded to Ripple lawyer John Deaton's plea for exchanges to list or relist XRP as a gesture of support for the verdict. This demonstrates the cause for which the crypto industry is fighting, with crypto professionals such as Binance CEO applauding the Ripple camp on their victory. For one thing, it nullifies the SEC's action against Coinbase, which sold 13 tokens categorized as securities via the exchange rather than through launchpads such as ICOs or IOs. Nonetheless, CoinDesk blogger Preston Bryan believes that the July 13 verdict just ensures continuing ambiguity, which only Congress can resolve. For the time being, altcoins have flashed green after learning that Gensler no longer has sole jurisdiction over them, implying a buying frenzy that saw XRP detractors miss out on 70 gains while Solana, Sol, Polygon, Matic, and Cardano holders profited by around 20. The SEC's announcement discussed Ripple's partial victory and how the court rejected the defendant's proposed test. Since late 2020, the SEC's EVs Ripple litigation has been ongoing. Now that we're in the third quarter of 2023, the globe is becoming impatient to hear the court's decision on this protracted dispute. Most people expect a favorable verdict in favor of XRP before the end of this quarter. The issue on everyone's mind right now is when the Ripple and XRP litigation will be resolved. A brief conversation about this occurred on Twitter among members of the online crypto community. Let's take a look at the many reasons why the XRP litigation has taken so long. According to this tweet, the reactions have definitely been about both parties of the litigation gaining time. According to one comment, the case generated a lot of attention, but if it takes a long time, people will lose interest. According to their remark, they predict that the value of XRP will ultimately skyrocket since it provides a valuable use case. As a result, investors of XRP, in their perspective, will acquire exponential riches over time. As a result, the SEC is attempting to lengthen the term of the litigation in order to dissuade interest, resulting in a smaller pool of persons profiting. Meanwhile, another respondent argues that the XRP litigation is taking so long because the court expects both parties to settle rather than go to war. At the same time, the same answer claims that Ripple is postponing the litigation in order to bring on additional on-demand liquid partners. Furthermore, according to another statement, the XRP case will not be resolved for another year. However, they failed to explain why they hold this opinion. Instead, another statement suggests that the XRP case might be extended for another year. According to this explanation, any and all delays are most likely attributable to the extremely sluggish speed of the American judicial system. On July 11, John Deaton disclosed some details about how much Judge Annalisa Torres charges for judgment on court matters. The XRP community is awaiting Judge Torres' verdict after Ripple and the U.S. Securities and Exchange Commission submitted reply papers in December. While it has been 7 months, Ripple is not Judge Torres' sole case. He said that the Thor Equities case's reply papers were also submitted in December, and that Judge Torres has yet to decide. He did, however, explain that Judge Torres delayed 7 months to announce her ruling in Quiller, Inc. versus Hughes, and 6 months in Fitzgerald case and numerous other instances. Deaton feels she has a good chance of ruling this month since she has taken her time. Ripple key to David Schwartz responded to Deaton, stating that he anticipates a summary judgment verdict would be issued before the end of September. Outspoken pro-Ripple lawyer John Deaton has voiced confidence about the SEC EVs. Ripple action, saying that Judge Torres would fully examine the central issue of whether XRP is a security in her future summary ruling. On Monday, Deaton said unequivocally, XRP is not a security. He then drew analogies between XRP and other assets like as orange orchards, whiskey, condominiums, and even Bitcoin. BCC, Deaton's thesis focused on the fact that, although being advertised and sold as investment contracts, these assets' basic qualities remained unchanged. Each was once sold as an investment contract, SEC shavers, but that particular sale didn't transform BCC into anything other than what it is, a digital commodity, he said. Furthermore, contrary to popular assumption, Deaton said that Judge Torres would not be afraid to confront the problem of XRP secondary sales. I believe Judge Torres must address the underlying asset and secondary market sales. Could she dodge the concerns and yet make a ruling? Of course she could. However, ignoring the SEC's premise and failing to address these difficulties would be a bigger act of judicial activism, according to him. To bolster his point, Deaton cited a similar case heard by Judge Castile in 2020 regarding the Telegram messaging software. This legal battle started when the SEC intervened and delayed Telegram's planned distribution of Gramcoin's planned distribution of Gramcoin. However, Judge Castile ruled in favor of the SEC, ordering Telegram to reimburse investors $1.02 billion from its failed initial coin offering, ICO, for the Telegram Open Network. It is critical to note that the SEC's assumption was that Ripple participated in ongoing activity resembling an ISO, seeing each sale of XRP as part of a larger strategy involving security. However, Deaton highlighted that the situation with XRP different from the Telegram case since the latter constituted an ISO with written contracts. Deaton further claimed that XRP, which is powered by the XRP technology, has been operational and publicly traded for more than 7 years. Notably, even SEC employees were able to acquire XRP until 2019. Which was not the case with the Gram cryptocurrency. The issue of XRP secondary market transactions has been a key point in the litigation struggle between the SEC and Ripple. While the SEC accused Ripple of marketing XRP as an unregistered securities, it failed to differentiate between Ripple's direct sales and subsequent secondary market trading, resulting to misunderstanding. Deaton recently said that Judge Torres may consider this issue based on a prior examination in the SEC versus Elbry action, since it puts additional light on the matter. However, although there is no assurance, Judge Torres' summary judgment opinion might shed light on XRP's security classification, possibly having a big influence on the crypto sector